Hi guys, Roland Jones. I decided to do a video on merchant cash advances because they're creating a lot of litigation in bankruptcy court. There's a lot of confusion. I think judges are confused. Funders don't know what to expect. Are these guys helping troubled businesses by being the last resort financing source, or are they predatory lenders? A lot of people have a lot of different opinions about this. I'm going to go into all the issues. Okay, like every video I do, it's not legal advice. Don't take any action on what I say. Don't refrain from taking any action. And if you're involved in a merchant cash litigation situation, then hire a lawyer. I'm not your lawyer unless you execute a retention agreement and I execute one. Video is not an admission of anything. It's for educational purposes. This table of contents. I'm biased. I think there are a lot of bad decisions coming out here. I think the decisions are ill thought out, are not based on good precedent, not really taking a careful look of the realistic practicalities of what funders are facing. But I'm going to go into the cases, and I'm going to let you decide. So what's the problem? Are these things are loans, or are they purchases or receivables? Well, to start with, what is a merchant cash advance? For those of you that don't know what I'm talking about. Well, you might say that that's the whole problem. What are they? And that's what courts are struggling with. I'll tell you what they're designed to be and what they say they are contractually. What they say they are contractually is purchase of receivables. But most people know what a factor is. A factor will purchase a company's specific receivables. So both parties know exactly what they're buying. Here, this is a purchase essentially of an income stream. It's not a particular receivable. It's a purchase of a percentage of money that's basically coming in the door. Theoretically, where is it coming from? It's coming from receivables. It's coming from businesses, customers or clients, but it's not a purchase of specific receivables. Typically, you're going to have a purchase and sale agreement that's going to say that. It's going to say it's a purchase of future income streams at a discount, and that's where the profit is. They're buying it at a discount. There's going to be a UCC filing. There's going to be a percentage of income. Theoretically, it's comfortable for the company to pay and stay in business. There's going to be an access to a bank account so that the funder can sweep the funds out when they come into the bank account without asking and delaying that issue. Usually there's not going to be a specific end term. There's going to be a reconciliation provision, which basically says that if there are fewer receivables coming in during a certain period of time, then the company will have to pay less to the buyer of the receivables. Why? Because there are fewer coming in. That's a reconciliation provision. And that's very controversial. Is there one? What does it look like? I'll go into all this stuff, as well as personal guarantees, default provisions, liens on assets beyond receivables. So the question with all these elements of an MCA is, does this turn it into a loan? Is this actually a loan? And if it is a loan, it's typically a loan at an extremely high interest rate. Or is it a purchase? Is this clearly a purchase, which is what it says it is? So that's the issue. So what do I mean by state of confusion? It means that judges are coming to different conclusions, in my opinion, based on similar fact patterns. Not always, but you do see that some courts seem to take a different attitude and weigh some factors. We're going to look at these sources of confusion when I look at the cases, but very quickly, both a loan and a purchase look exactly the same transactionally, and I'll go into that. Income versus specific receivables. So some courts say, how come the buyer of the receivable is not doing any due diligence into the underlying debtors? How come it's not collecting the money? Looks like that makes it look like a loan. It's not doing any of those things, but not necessarily. And the argument's contrary to that. We're buying intangibles. And what if we're buying intangibles? What if we're purchasing something that's in a bank account commingled with other dollars? So does that mean we're not really buying it? Does that mean it's more like a loan? There are a lot of problems with forms. Judges are using the language on forms to draw conclusions, which I think doesn't make any sense. I'll go into that. Some judges say we have guarantees of performance. In other words, judges are viewing some of the guarantees, warranties, as guarantees of payment, where they actually might be guarantees of performance. These merchants are going to do what they said they're going to do, or otherwise there's going to be a default. But I think judges are confused about that. There's also a big question about reconciliation, whether that's really a right that the merchant has or whether that's illusory. We'll go into that. The ultimate question is risk, and every court faces this. It's the ultimate question. If a buyer of receivables is subject to the risk of default of those receivables, then you would think it's a purchase because it got skin in the game. But if it's a loan, then there's no skin in the game. The merchant has to pay no matter what. Even if all their account debtors, all their receivables bust, they still have to pay. It looks like more of a loan. So how risky is any particular merchant cash agreement contract? And that's a huge question. And I think judges are getting that wrong. They're confusing performance with warranties, and I'll go into that. Not to beat a dead horse, but this is a big problem. I mean, when a transferee, a funder buys receivables, money is going out to the transferor. And the same thing in a loan. Money goes out. In a purchase of receivables, the transfer will send what was acquired, the receivables, in the form of money back to the transferee. And that's done with a loan as well. So you really can't tell the difference if you just look at them. I think judges really have different perspectives on whether these merchant cash agreement funders are good guys or are they bad guys. And then everything flows from there. Because once that bias takes hold, then you're going to look at the evidence differently. It's like a murder investigation. If if the police are focused on one suspected perpetrator, they're going to ignore all the other potential perpetrators, and they're going to focus and they're going to look for evidence against that particular individual. And it's the same thing here. Well, I think once a court decides that these guys are bad or good, they're going to look for evidence to support the judgment. And I'll show you exactly what I mean in the opinion. I made this chart because the difference is so stark between courts on what these guys are doing. And I'll go into this again later. I just wanted to show it to you now. But basically, finding that these things are loaned, does that protect creditors or is it worse for creditors? And all these issues. Basically, opposing viewpoints and very different conclusions. And I'll go into each one of these as we look at the cases. All right, so how do these things show up? And why am I interested in it? So I'm a bankruptcy attorney. First place they show up is in state court or district court. Funders are trying to get their receivables. There's a default. And the merchants that sold the receivables say, all of a sudden, it's a usurious loan. So we're not going to give you the receivables. So the funder is out possibly hundreds of thousands of dollars. And guess who gets to keep the money? The merchant. There are RICO actions by merchants. I'm not saying, that happens all the time. In other words, there are bad guys, there are good guys. But I think what happens a lot is that you have a few bad apples and then it casts a pall over the entire industry, and the good guys are made to suffer by the courts because of reputational issues. There are RICO actions where merchants are getting together and trying to punish some of these funders. And I've read some of these cases. There are some terrible circumstances as well. But mostly it's bankruptcy court that I'm concerned with. So funders are filing claims against the estate. And is this the property of the funder or is it the property of the bankruptcy estate? And what I'm most involved with is preference clawbacks, fraudulent conveyance clawbacks, the not use of cash collateral. I'll go into all this stuff. But basically, everything hangs on, is this a loan or is it a purchase? A loan, there are huge implications and possibly criminal implications for the funder. So there's a lot to lose here by a funder. It's extremely risky. And not just for funders, there are other implications. Well, uncertainty as far as legal uncertainty for funders. I don't know what the hell's going on. I mean, who knows what a judge is going to do with these things? Unless you're in front of the exact same judge that just rendered a decision for a funder or against a funder. There's going to be higher costs probably. The more uncertainty, purchasers of receivables are going to charge more because it's more risky. There's a chance they're going to end up in bankruptcy court. They're not going to get anything. Not going to get their capital back. And then there's the implication that there are more companies in bankruptcy because of unethical funders, predatory lenders. They're forcing these companies to go into bankruptcy. They're bad guys. And then there's the opposite argument that these good guys are providing last resort financing, and so there will be more companies filing because these guys are not going to be available if the courts destroy the industry. So the argument that trade creditors are being hurt, and there's the argument that trade creditors are being helped because where does the money go for these purchases of receivables? It goes to trade creditors. So instead of filing bankruptcy, company is using this money to pay trade credits. If it filed for bankruptcy, these funders aren't around. A lot of these, against the wall companies are going to file bankruptcy, and trade creditors are not going to get paid. And so who is the court helping here? Who's the good guy? It's not very clear. If the company is completely insolvent and there's a secure creditor with liens on everybody, maybe the judges are helping the secure creditors. I don't know if they need help. All right, so in the rest of the video, I'm going to be going over cases and law reviews in a lot of detail. By the way, I will be submitting this for continuing legal education credit, so that's a possibility, but it hasn't been approved yet because I haven't finished it. I have to submit it. So if you want credit for it, check back, I would say, in a few months. Anyway, this is a Maryland bankruptcy case. I'm only going to look at pretty much really recent cases. So this was decided this year in March. So I put this summary up, but we'll look at the case. But if you want to flip back to this at any time, you're welcome to do that. So courts generally, bankruptcy courts apply a 3-factor test. That's the way the law has shaken out over the last, I would say, 25 years. Most courts apply a 3-factor test, but it's not really a 3-factor test because they look at a lot of other factors, and there's a lot of talk in all the opinions. It's not just the 3 factors. We're going to look at everything that's going on, and then we're going to make a decision. Other factors, there's a lot of vague language about that. But the basic factors they look at is there a reconciliation provision in the merchant cash agreement? Is there a finite term? And is there a bankruptcy default provision? And the rest of the notes I'll be discussing during the case. So the context here, this is a fraudulent conveyance, a clawback case, and trustee is seeking to claw back $145K, which was paid to the funder pre-petition. So there's a very common fact situation. And the court says a threshold question raised in the case is whether the MCA agreement constitutes a loan or a sale. That's the fundamental question. And the court determined to adopt the majority view, the purpose of this case, namely to apply the non-exhaustive three-factor test. So it's not only those three factors, but those are the main factors. It gets the conversation going. This is an environmental services company. And you have to remember, the only reason anyone does an agreement like this, funding agreement with sells receivables, because they can't get bank loans. They can't get any other kind of loan. This is the last resort. So eventually Global filed for bankruptcy, but it's not a big surprise. It shouldn't be a surprise to anybody. They can't get financing. Their credit apparently is not very good, or they wouldn't have done this deal. This isn't the first choice for anybody, for any company. Anyway, this deal was done, agreed to buy 290K receivables for a purchase price of 200K. Eventually they were transfer, it depends if you're seeing this as a loan or a sale. I'm going to assume it's a sale. And they were given back 145K in receivables, which they purchased. When they're buying receivables, they're buying something that doesn't exist yet. It's like a pre-purchase. They're buying and then they're going to get it later. So here, trustee is appointed, as a bankruptcy trustee is appointed, and trustee is basically saying, Your Honor, throw the book at these people. Hit them with the book. Fraudulent conveyance, preference, turnover. Anything else I could think of, I'm suing these folks for, and we want the money back. This was their perspective. Trustee's argument is that this is a usurious loan. There's a usurious loan. The implication is, really, these are bad people. They're extending a usurious loan, taking advantage, and Your Honor should compel the return of any money that was paid to these people. They should be punished. That's basically the argument of the trustee almost every single time. But it's also, the funder also filed a claim against the estate, and of course the trustee is going to want to wipe out that claim. So the court set out the three factors and summarized it this way. The hallmark of a loan is that the lender is absolutely entitled to repayment under all circumstances, but otherwise principal sum is repayable. Absolutely. The root of the analysis involves the question of whether the transaction involves a transfer of risk. And we're going to apply the factors. The reconciliation is the first factor, because it's critical, because it goes to the heart of what this is or what it's not. If it's a purchase of receivables, then there's always the risk that if you're buying an income stream where you're getting paid a percentage of an income stream, the risk is that the money's not going to come in. The customers of these folks, of the merchant, the clients of these folks are not going to pay any money for whatever reason. That's the risk. That's the risk you take if you buy an income stream. And so if you're getting a percentage of the receivables, and let's say 100K receivables comes in 1 month, and the next month business is bad, or they're losing business, or they're losing customers. They only get 50K in receivables. So if you're getting, let's say, 10% of the receivables, first month you're going to get 10K if it's 100K, but the second month the merchant should be able to do a reconciliation. In other words, go to you and say, look, this month we only got, whatever it is, 50K in receivables. We didn't get 100K. So you're getting 10%, you're only going to get 5K. You're not going to get 10K this month because the receivables didn't come in. You bought the receivables, that was the risk you took. The implication of that is not only that funder is going to get paid fewer amounts of receivables, but it may take a longer period of time for the funder to get paid. In other words, a loan typically has a fixed term. You're going to repay the loan in 5 years, 10 years, whatever, or you default. And you have to pay every month the same amount. That's what a loan looks like. Everybody knows that. You're really buying receivables, then you're not getting the same amount every month. And there's no fixed term. It could take 20 years. If you're buying X amount of receivables, it could take, who knows how long it's going to take for you to get paid. So that's more like a purchase. There's a big risk because the longer a funder has to wait, the worse deal it is for the funder. And if it's too long, the funder would have been better off putting his money in the bank and getting a steady interest rate. And it's easy to see that. So this is a critical provision. And here, the reconciliation provision was mandatory. In other words, the funder didn't have a choice. The funder didn't say, well, we don't want to reconcile. Or it's not a situation where we think reconciliation is appropriate. Can't do that. So if it's mandatory, the court's going to find, much more likely to find. Again, it's one factor, but it's a very important factor. And so the question arises, what if the reconciliation provision says, well, the funder is willing to reconcile and essentially take fewer receivables, take less money if certain documents, if the evidence is provided, if. So is that a reconciliation provision that's enforceable? Is that real? Or is that illusory? In other words, is that just window dressing and it's really a loan? So that's an issue we're going to talk about later, but it's a very important issue. The other issue is what if the merchant tried to assert the provision in reconciliation and the purchaser just decides, we're not going to do that and just completely refuses? Is that breach of contract or does that turn the contract into a loan? So that's an interesting issue as well. The second guiding factor is whether it's a finite term. I'm not sure why there are two factors because that's determined by the reconciliation, the existence of a reconciliation provision, like I was just saying. So, and I think the judge basically implies the same thing. If the monthly payments can change, then the term of the agreement is not finite. It's essentially the same thing, in my opinion. So the last factor the court's going to look at is there recourse in the event of bankruptcy? And here the contract says specifically there's no recourse. You can go bankrupt, and there's no obligation for any third party to pay. And the question is, did the merchant guarantee payment? Did the merchant grant liens on other property? And is there language saying that if there's a bankruptcy, we get to execute on those liens? Or we're a secured creditor going into bankruptcy? Is there a personal guarantee that guarantees payment? If there's a guarantee of payment in the case of bankruptcy, then the court's going to draw the conclusion that there's no real risk here. It's a loan. It's a loan because there's no risk. There's going to be bankruptcy, the funder is going to be guaranteed payment. Looks more like a loan than a purchase of receivables, which involve risk. And here, of course, funders are not fools, and they have lawyers, and they're going to draft agreements that address the potential issues of being in bankruptcy court in front of a bankruptcy judge. And I'm sure that this was drafted with the three factors in mind. I mean, it's just clearly a well-drafted agreement that's going to address these issues. Unfortunately, the language in an agreement is often not respected by judges, some for good reasons and some for bad reasons. But here the language is pointed at and respected. It's hard to ignore that says specifically bankruptcy is not among the events. So it's very clear in this situation. So here the court also looked at other kinds of recourse. Here, the funder had a security interest in all future receivables. So does that make it look like a loan? Does that increase or decrease the riskiness of this transaction? And the court said no, it doesn't matter because it's not a security interest in everything. It's a security interest in the future receivables, and it's a judgment call. It's just not enough protection according to the judge. There's also a personal guarantee, which is the bugaboo of a lot of courts. Here there's a personal guarantee, and the judge is saying, this is a guarantee of performance, of what the merchant is going to do or not do. The manager or the owner of the company is going to do or not do. In other words, they're going to follow the agreement. Are they going to transfer the receivables? And if they breach the agreement, then you're going to have the personal guarantee and execution on personal assets, I assume. Now here, in almost all these opinions, you don't actually see the personal guarantee as an exhibit to the opinion. You can't read the personal guarantee. But here the judge is telling us it doesn't guarantee payment. It just guarantees performance. So we don't know what it says. But a personal guarantee and liens are a big issue for other judges. And personal guarantee in other situations will have the court render an opinion finding that this is actually a loan because a personal guarantee other judges will say that goes into certainty of payment. And we'll look at that. So this is another case involving merchant cash agreement. In this case, the court takes a very different point of view as to the funder and what the agreement really signified. And this is a bankruptcy case, again, Southern District, New York, May 30th, only a few months ago, very, very recent case. We're going to look very closely at this because I think it raises a lot of issues common to other cases. So the judge is going to grant summary judgment in a preference case brought by a trustee. It starts out by saying there's state law, case law that he's going to use as precedent, as well as RICO law. Judge notes what these are and how they're usually set up. It's a purchase of cash flow, and there's usually a reconciliation agreement. And the issue is this an asset sale or is it a loan? Judge says he's going to look at the course of conduct and the agreements, and he cites the Fleetwood case and decides that this is in fact a loan. As a struggling subcontractor does his deal with an MCA company and goes bankrupt. And the MCA company is sued by the trustee. So that's a quick summary. But there's bad news right away in this case. Apparently, According to the judge, defendant failed to respond to admissions. So this is a huge problem. According to the judge, there was a 7056 statement filed with the summary judgment motion, and that wasn't contradicted. So there's a problem right away. Judge goes into the facts, but for the purpose of this video, they signed contracts and the MCA got payments in the preference period. So the judge points out that the defendant already admitted everything. Look at number 6. Transfers were on account of an antecedent debt. That's admitted over and over again. So there's no defense because these things were admitted according to the judge, since the request for admissions was not responded to and there was no motion withdrawing admissions. So the defendant is basically done here, but the judge is going to go into the facts anyway. Are these things loans, or are they assets that were bought by the funder? And if they are loans, is there a defense of the preference case? Citing Fleetwood, court says New York courts usually weigh these factors in making the determination whether it's a loan or asset purchase, whether there's a reconciliation provision, whether the agreement is finite terms, and whether there's any recourse. And notes that these 3 factors provide only a guide to the analysis, not dictate the conclusion. So there may be other factors. So the first question is there a reconciliation agreement or isn't there? So the court says, applying these principles here, the agreement lacked reconciliation provisions that would cause Radium 2 not to receive more than the share of receivables purportedly purchased, because the agreements do not bind the defendant to pay back any money collected that exceeds the specified percentage of the debtor's revenues. Yeah. So I want to talk about that a little bit. First of all, is there no reconciliation agreement, or is there a reconciliation agreement that doesn't require return of money for past purchases? If there was a reconciliation, in other words, why isn't the agreement being quoted or cited here? It sounds like there was a reconciliation agreement, just not to return money. In other words, maybe there was less cash flow in the past or less the month before, and the funder didn't return that. So I have a lot of questions about that, because my question is this. So was there any request by the company, by the subcontractor, to adjust based on cash flow? Was cash flow actually less? Was there a denial? Was there a refusal? To me, this is breach of contract, because the meeting of the minds here, the purpose of the contract is to buy cash flow, and if there's less, and to take a percentage of that cash flow. So if there's less cash flow, the funder should get less money, because the percentage would equal less money, less cash. And so if the funder is refusing to adjust based on the agreement of the parties, to me, that's breach of contract. Why do we get to recharacterize the agreement? In other words, does breach of contract by the funder, does that equal it's now not an asset purchase? It's now a loan? So that's just something to think about. Then the court says the agreements have no stated maturity date of finite term. So according to the agreement, there is no finite term. And that's the second factor. But the defendant's principal admitted in the deposition in this case, offered by the trustee, uncontroverted by the defendant, that the agreements had a de facto fixed term, or de facto fixed terms. When asked how long is this out, therefore, the defendant's principal responded, they're all different. It depends. Usually it's an amount of days. It's the payment deducted by what you're purchasing. I don't know what kind of evidence that is. Who's testifying? And what do they mean by that? I think it's the same issue as the reconciliation agreement. Maybe the cash flow didn't go down. The facts are not really set out here as far as, was there a refusal? Was there a request? Did the cash flow go down? How much did it go down? There's just basically a statement by the court without really going into the details of the agreement that this is a finite term. I don't know if it's a finite term. What if cash flow went down? And what if there had been a request? Then it wouldn't be a finite term. Why is it a finite term? It's not that clear to me. Now here, everything's been admitted anyway, but if there were facts like the subcontractor testified that cash flow went down and the 7% of that cash flow was less money, and so the payment should have been less, the daily or monthly payment should have been less, and that was brought to the attention with documentation to the funder, and the funder said, no, forget it, you're going to have to pay the same amount and every single time, doesn't matter what your cash flow is. Okay, I can understand that would be a finite term and lack of a reconciliation provision. But those facts are not stated here. They're not presented here. I mean, the defendant was dead in the water from like the first sentence of this opinion anyway, because everything's admitted. But then the court looks at the other factor, which is if there's a bankruptcy, there's a default. And presumably the default provision would require full payment immediately. The agreements do not list the debtor's bankruptcy as an event of of default. They even include language contemplating that the debtor could go into bankruptcy and not default. But the court says, well, that's not positive, and that we're not going to weigh that a lot anyway because of what follows. The point of the lack of a bankruptcy default clause is that it shows that the funder is at risk. If there's a bankruptcy, the funder is not going to get anything, or at least not more than what he's already been repaid or what he's been paid pursuant to the agreement. But here is very clearly stated that bankruptcy is not a factor that would create a default. But the court points out that there is a personal guarantee. Because of the personal guarantee, the court seems to be discounting the language in the agreement, and he's saying that it doesn't matter, essentially, because there's going to be a default of the personal guarantee. The court doesn't go into the language of the personal guarantee. Generally, personal guarantees are made to guarantee performance, that the merchant is going to follow the contract, perform on the contract. There's no quote from the personal guarantee, but there is a statement that says, however, as the scope of the guarantor's liability does not extend beyond the scope of the debtor's liability, meaning there's no bankruptcy default. There can't be a default under bankruptcy. That's the debtor's liability or contract under the agreement. This factor may weigh slightly, but not decisively, against classifying the agreements as loans. So the courts, up to this point, we don't know how the court's weighing any of these factors, and we don't really have a lot of facts to support for and against on these factors. Here the court is saying, from a broader perspective, the agreements have little similarity to an asset sale. They don't look like asset purchases. They don't smell like assets. And why is that? And the court explains, it's because they're not really buying, it's not like a traditional factor. The funder is not buying specific account receivables, buying an income stream or a percentage of a future income. And so the funder, unlike a traditional factor, they can't collect directly from the debtors' customers' receivables, and they don't have to do any due diligence. So it doesn't look like a purchase. So why doesn't the judge recharacterize the agreement as the purchase of an income stream instead of including that it's a loan? I mean, that is another option. The court goes on to say that there's no risk here because if any specific account debtor of the merchant doesn't matter because the merchant has to pay X percent of cash flow. But it's not that clear to me from the facts that there's testimony that subcontractor ever had less cash flow. If that happened, we don't know that ever happened. If it did happen, maybe this money would be made up by other receivables. Or maybe the merchant considered this, and this was part of the factor of the merchant in entering into this agreement. It's not clear to me that there is a finite term. And it's not clear to me that there's no risk either. There could be no cash flow. There could be a bankruptcy. And the court agreed that the personal guarantee doesn't help the funder here. So what if there is and there was a bankruptcy, and the funder wasn't paid. And not only was the funder not paid, but is being sued for a preference. Obviously, there's risk. The funder wasn't paid, and the court says that in the next paragraph. There's a huge claim, probably of capital. In other words, probably the funder is taking a very significant haircut here. It doesn't say anything about whether the funder was able to recoup on a personal guarantee. I would assume not, filing a claim here. And the court says, well, the fact that it filed a claim makes it a creditor. And the problem I have with that is that maybe it shouldn't have filed any claim and asserted property rights in future receivables, but it did file a claim. But there's nothing in the claim form. The claim says anyone that files a claim is a creditor. It says that on the form. It refers to any claimant as a creditor. So if the funder wants to assert a claim through a proof of claim, it's got to fill out the form. There's no option for crossing out creditor and saying, we're a purchaser. I'm not sure how that can really be used against the claimant. It doesn't seem fair, or maybe from the funder's perspective, it doesn't file a proof of claim, and the judge finds that, sure, funder is going to expect the issue of loan versus asset to come up, and possibly the funder is going to expect to be sued for a preference or fraudulent conveyance. And if the judge finds that this was a loan and not an asset purchase, and there's no proof of claim filed, and there's a bar date for claims, then the funder is going to lose out on getting anything. So it seems like the funder is in a very, very difficult situation here, and that's probably why the funder filed a proof of claim. It's in the nature of alternative argument. There's nowhere on the form to say that, so seems a little bit unfair. Then the funder tries for an ordinary course defense. It's a Hail Mary. It's denied, of course, because this is an unusual payment. There could have been other reasons to deny, but that was the reason to deny the ordinary course defense. End of story. So this was published like last month, or month and a half ago. It's a very hot issue. This is Duke University professor Stephen Schwartz, recharacterizing contracts, the sale versus loan problem of receivables financing. So I'm going to go into this article in a lot of detail, parse it, because it goes into these issues and cites current case law and proposes a solution. And is extremely adept at navigating these shoal-filled waters. Anyway, the jurisprudence on the sale versus loan problem is muddled and inconsistent. The confusion is compounded by the intangibility of receivables, subverting the old adage that possession is 9/10 of the law. But the only well-established legal principle is that a court may sometimes, though it is unclear when, recharacterize a transaction that parties deem a sale to be a secured loan. So, in summary, things are a mess in case law. There's a lot of uncertainty, and it's threatening to destroy a source of financing, if I could summarize. And there's a cost to this uncertainty. The cost is going to be hard to finance your business. Funders aren't going to do this anymore. If they're hauled off as usurious lenders, or if they don't get their capital back, and if they're tarred and feathered, they're not going to show up anymore. First thing the judge says is they look the same. So it's a challenge. They look exactly the same. So it's very difficult to distinguish what is a loan and what is an asset purchase. The first thing the professor goes into is the issue of recourse, personal guarantees, things that cause default. That recourse simply reflects the transferor's assurances about the quality of the receivables being transferred. It's not a guarantee of payment. It's a guarantee of quality. And I think a lot of courts get confused about that. Courts often view the existence of recourse, however, as inconsistent with a sale. Because courts are basically saying, if there's personal guarantee of payment, then it's a loan, because there's no risk. It's a loan. You're not buying anything. You're not buying receivables and possibly end up getting nothing if the cash flow ends, or if account debtors don't pay what they're supposed to pay, there are not going to be any receivables. But what courts are confusing is, and this is according to Professor Schwartz, confusing a warranty of quality, a warranty of performance, with a guarantee of payment. And there's a big difference. This need for sellers to provide recourse to buyers regarding the quality of the property sold is as important for the sale of receivables as for the sale of goods. When you buy a car, there are warranties, there are guarantees. Doesn't mean it's not a sale. Doesn't mean it's a loan. They're guaranteeing that the car is going to work. They're guaranteeing service on the car, whatever. They're making guarantees. They could be guaranteeing the quality of the car. It doesn't mean it's not a sale. And receivables is the same thing. The argument goes, there's a personal guarantee, and there are other forms of recourse. There could be liens and stuff on other property besides receivables, because they're guaranteeing performance or they're guaranteeing quality. Doesn't mean they're guaranteeing payment. So the problem is not that there are factors. The problem is that there are a number of different factors really that are applied, not just three, more than that. And one court may apply some or not other ones and weigh them completely different. So and the other side of the argument is, well, the facts are different in each case. But it makes and that may or may not be the case. We don't know. We don't know how another judge is going to rule on the exact same facts. Maybe another judge would weigh factors differently or not consider factors. However, courts differ in the factors that they consider and the weight given to each. 4 factors nonetheless dominate. Actually, in New York anyway, it's supposedly 3 factors, but it is 4, as you could tell in the last opinion we read. Or more. 4 factors nonetheless dominate: risk allocation or recourse, rights and obligations regarding surplus and deficiency. Actually, I don't see that in New York. Control over receivables and collections. We did see that in the last opinion. And contractual language, which is usually dismissed. Actually, these aren't the 4 factors that I've encountered in New York cases. But anyway, it may be an interpretation of the factors, just relabeling them. So recourse, by far the most significant factor the courts consider is recourse. Another factor the courts look at, this professor characterizes as surplus/deficiency. So this is the same as reconciliation, or if the contract is missing a reconciliation provision, or it's impossible to actually execute a reconciliation promise by the funder. And so the issue is the same thing as recourse. Is there risk? Is the funder at risk in purchasing these receivables? And if the funder's not at risk, then it looks more like a loan. And the question is, here is the second factor that the professor identifies. And the question is the seller obligated to cover deficient collections. So basically that's the same thing as reconciliation, because the situation is there's less money coming in, there's less cash flow, and the amount of daily payment or monthly payment or whatever it is should be lower, because it's a percentage of the deal is a percentage of cash flow. And if it's not lower, then essentially the seller, recipient of the loan, however you want to look at it, is guaranteeing deficient collections. So that's the issue that's raised here. Well, the factor is the control over the receivables, and some courts find that. And the article is going to go into all these factors and provide a critique of the current case law. But essentially, this is whether the funder can collect directly from the seller's account debtors. In other words, can the funder collect these account receivables? Did the funder do due diligence to these account receivables? Were these account receivables commingled? Those kind of issues. Is that relevant? Should the courts consider that, or should that not be relevant? And the last thing is, should the language of the contract be respected? The deal that the actual parties made, do we just throw that out? Or should that be weighed as a factor? And most of the time in the case law, it's not. Sometimes it is. So that's another issue. I think the main focus of this article is concern that the courts are misinterpreting recourse and overemphasizing recourse. Also, that there's a failure to differentiate between different kinds of recourse, between quality recourse as to the quality of the transfer of property, a recourse as to the performance of a contract. However, full economic recourse, which would provide the transferee of receivables with a specific guaranteed rate of return regardless of losses or delays in collections, that would obviously be more of a loan, because there's no risk being transferred. But one of the main points of this article is that there's a lot of confusion as to recourse and really what it means. Is it a guarantee of payment, or is it a guarantee of performance? Is it a guarantee of quality? Last category of issues considered by the courts is considering irrelevant, a critique of those cases, considering irrelevant factors. So here's the focus is on, did the buyer do due diligence on the receivables? And basically the professor is saying it's not relevant. It's not important, it's not relevant, because the purchaser is buying cash flow. It's not buying any specific receivables. And also this duty is more economically performed by the merchant. And not, so it makes sense. Basically, the professor is saying it makes sense. Let the merchant do this. What does the buyer know about these receivables? The merchant is intimately connected to its clients or customers, in a much better position to gauge the quality of these receivables. Are they going to pay or not pay? And the merchant's going to know that, not the purchaser of the cash flow. The professor is taking a stab at how to analyze these properly. First thing is respect what the parties contracted for. If there's specific language that it's a sale, then respect that. Then it's a sale. These are adults that are entering into an arm's length agreement. Number two, if there's recourse, personal guarantees or security interests that cover performance, that guarantee performance or are warranties of quality of the receivables, that doesn't mean it's a loan. That shouldn't be evidence of a loan. Three, the contract may freely allocate surplus value of the receivables between the transferee and the transferee. Talk about that later in the video. And the contract either gives the transferee the right to further transfer or sell the receivables, or is silent on alienability. So if it can be sold or it's silent on that issue, then it's a sale. I'll go into that later in the video as well. Here the professor is saying, why are the bankruptcy courts involved in recharacterizing anyway? The purpose of the bankruptcy court is to ensure equality of treatment for unsecured creditors and to aid the rehabilitation, the reorganization of companies. How does this help? In fact, it could hurt, because if we wipe out this source of financing, there are going to be more bankruptcies. You could have situations, a lot of situations, where companies that got this financing did not file bankruptcy because they got the financing that they weren't able to get anywhere else. Also, a lot of this financing seems to go, as far as I can tell, to pay unsecured creditors. That's where they're paying vendors to stay in business. They're using the financing to stay in business. So, and if the company had gone bankrupt without this financing, those vendors wouldn't have gotten paid. So the argument is, it's not really, the bankruptcy court doesn't have a dog in this fight here. It's not appropriate for bankruptcy courts to recharacterize, because it doesn't do anything. I mean, arguably, the other side of the argument is, if it's a loan, then possibly there could be a preference recovery. But if it's a secured loan, there may not be a preference recovery. Maybe there'd be a fraudulent conveyance recovery. I mean, that's arguable. Maybe there would be use of cash collateral. But there are other sources of financing, the professor says. So it's questionable whether this is really appropriate for a bankruptcy court to do. And it might be causing more bankruptcy. According to the professor, it's misguided. Unbalanced, therefore, bankruptcy policy should not justify recharacterization of receivable financing contract. Not helpful. The professor looks to apply his analysis and take a look at case law that he wants to critique. So the first case is Shoot the Moon. We're going to be looking at that case in detail later. And the professor says the court weighed heavily that there were security interests, broad security interests in assets beyond receivables, and decided this is indicative of a loan, not a sale. And the professor's critique of that was that observation, however, should be irrelevant to both the transfer of receivables and this article's framework. The security interest merely backed whatever obligations the transferor had. It's in the nature and extent of those obligations, the recourse, not the transferor's creditworthiness to perform them, which should be relevant to sale versus loan characterization. So, they back performance. They back warranties or performance. It's not a guarantee of payment and should not be relevant to whether this is a sale or a loan. Well, for the same reason, the personal guarantees should also be irrelevant. And why is that? Because it has to do with whether the transferor is going to do what the transferor has promised to do. It's creditworthiness. It's performance. Nothing to do with whether it's a sale or a loan, and nothing really to do with the riskiness of the underlying account receivables or whether they're going to pay or not, or whether the cash flow is going to continue. It has to do with the contract. Are they going to adhere to the contract? The next mistake made by the court, according to the professor, and I agree, is the court's use of a UCC filing. The court stated financing statements contain another revealing indicator that they relate to secured loans. They identify the transferor as a debtor. You have to use this form. Whether you're purchasing or making a secured loan, it's the same form. And that's the wording on the form. You can't cross things out. And it doesn't make any sense at all to see this as a piece of evidence. It's like the proof of claim form. It's a form. It's a pre-printed form. Okay, this observation should be of no import because it conflates the UCC's application to both sales and secured loans, treating both as secured transactions for perfection and priority purposes. So that's not relevant either. The court also looks at commingling of proceeds. So commingling is irrelevant. It has to do with control. It has to do with the nature of the receivables, the intangible nature of buying a cash flow, and it has to do with the servicing of the receivables and the due diligence. The seller doesn't have to do due diligence, and of course he's collecting the money, and that shouldn't be an issue with the purchase of cash flow. So you can recharacterize if the contract says it's a purchase of receivables, it should be recharacterized as a purchase of cash flow instead of being recharacterized as a loan. Shoot the Moon, apparently there were phone calls or texting, whatever, referring to this as a debt or as a loan. And the professor says this is not relevant. It doesn't change the legal nature of the contract. And it's discussion by non-lawyers has no place in the analysis. Not evidence. It's irrelevant. So in summary, this is a sale. It should be characterized as a sale, not a loan. The language is very clear. It's not intended. It says specifically, it's not intended to be, nor shall it be construed as a loan. Second, there's no repurchase agreement, which would make it look more like a loan. Third, it can be sold like a purchase. The receivables can be resold by the purchaser. This should have been characterized as a sale. And the other elements are irrelevant. So CF Motor, the contract said it's very clearly it's a purchase, not a loan. But here, if a receivable failed to collect within 60 days, the transferee had recourse for repayment of the amount advanced. So this does give some recourse. And the question is, does this turn it into a loan? According to the article's framework, no, because the other factors are met. Also, the 60-day guarantee is return of capital. It also does not take away the risk of the length of repayment. It says if all the receivables are going to be 60 days late, or some of them, or at different times, it's going to change the payment dates. So that is a risk that remains. Also, it's still alienable. The other factors are met, so it should be still a sale. So in AgriCap, it was specifically stated in the agreement that it's a sale, not a loan, and there's some recourse. There's some guarantee here. The transfer had recourse against Robinson Farms receivables remaining unpaid past the specified period unless the obligor on the unpaid receivables have become bankrupt or insolvent. So there's still risk because the account debtors could be bankrupt or insolvent. Then there's no guarantee of payment. There's also no guarantee of payment on time, which can make a big difference. So they have recourse to some degree. You could also construe that as being, as the professor says here, an R&W. So in other words, a warranty of quality. So the professor here says, these are warranties of quality of receivables. They're not guaranteed. It doesn't turn a sale into a loan. It's not full recourse. It's not guaranteed. And there's still risk. So this also meets the professor's criteria for a sale, and it should have been a sale. So I don't think bankruptcy judges are going to appreciate this. So basically, he's saying that there should be commercial courts created, where specialized courts where these kind of issues are decided. Because although bankruptcy judges have narrow expertise in bankruptcy law, they may well lack expertise in commercial law. In other words, they're out of their depth. They don't know what they're doing. I don't think that argument will be appreciated. And I'm not making it, by the way. I'm going to take another look at a law review article, this time by Professor Kara Bruce, another law professor at a different law school, who takes the opposite point of view. I'm not going to put words in professor's mouth, but it seems to be the concern that these are predatory lenders that are creating havoc and putting companies into bankruptcy and charging usurious interest rates, and they must be stopped. So I'm going to go into this article and her rationale. So this isn't the first time Professor has written about this. This is a little bit of a crusade. I argued that many MCA agreements are loans in sales clothing and therefore are vulnerable to usury challenges that could void the underlying transactions. So what she's saying is when she wrote her first article, no one was listening. Now, got a lot of courts listening. Is that a good thing? Is that a bad thing? You can decide. Well, the professor gave a summary of what these contracts typically are like. And already there's inflammatory language. It's a little bit of a polemic. MCAs have been notorious in recent years for their aggressive remedial provisions. Maybe some have. I mean, there are cases where the judge is obviously sympathetic to these funders, and some situations where there's been egregious abuse. But I think this professor kind of lumps every funder into the bad apple category. Not surprisingly, MCAs can have a significant and immediate effect on business operations and further deepen a business cash flow problems. Well, they're also getting funded and staying in business. So, it's a little bit unfair, I think, how this professor characterizes funders. I'm not saying you read the cases, there are definitely situations where funders have done terrible things. They're like thugs. But there are a lot of situations where they're not like that. I would venture to say that my guess is the vast majority are not like that and are just are decent people with families, backyards, and kids in school. So the professor continues, many MCA funders lie low through the bankruptcy case as if they're criminals in hiding, taking no action, lying low. Others aggressively assert their interests. Why shouldn't they? If they're owed money, especially if property belongs to the funder and it's not being handed over, it's being treated as part of the estate. They have to be aggressive about asserting their interests. It's not necessarily a slur on funders that they're aggressive. They should be aggressive. I mean, the professor points out that it's controversial. The bankruptcy courts are not uniform in dealing with a true sale, and she points out that one court raised the 363 issue. It says that it's a purchase of something that's created post-petition, the receivables created post-petition, then the funder would actually need court permission to approve that sale. I don't know about that argument. I think it's kind of thin. I think there's one bankruptcy case that says that. Well, here the judge says that the MCA withdrawal, obviously classification, is it a loan or a purchase is very important. It affects a lot of things. Here the professor says the MCA withdrawals preceding a bankruptcy will frequently be preferential in effect, as they allow the funder to receive more than it would have if transfers had not taken place. Not really. Not if it's their property. If it's their property, it's not a preference. It never went into the estate, and they would always be paid the same thing, whether there's a bankruptcy or not. So it's actually incorrect. If it's a loan and they were paid during the preference period, yes, clearly there's an issue there. It might be preferential, and there might be safe harbor defenses to defend that. But that I think that sentence is just incorrect. Yeah, of course, MCA funders have also argued that they're not creditors. No, that's all. That's basically all that they argue. Every single time an MCA funder is going to say it's not a creditor because it's not. According to the contract, it's a purchaser. So if that contract is later recharacterized, then a court may deem them to be creditors. But I've read a lot of cases. I've never seen an MCA funder argue, at least, it may argue on the alternative that it's a creditor, so it will have a claim against the estate. But its first argument is always going to be that it's a purchaser. It's the owner of the receivables of the cash flow. And the professor rightly points out that that the transfer to an MCA funder might be considered a fraudulent conveyance if it's not reasonably equivalent value. But she's also right in saying that it's probably not going to work most of the time because they're transferring large amounts of cash, of financing, to a struggle company. And the company is using that cash to pay trade creditors. And it's also an arm's length transaction. So it's going to be difficult unless the bankruptcy court is going to recharacterize it as a loan and as a usurious loan. It's going to be difficult to prove a fraudulent conveyance, although it could happen. I mean, the professor pointed out there is a case that found that the entire transaction was a fraudulent conveyance. I disagree with the rationale of that opinion. Now the professor starts to talk about recourse. The cognitive dissonance arises because the MCA's default acceleration clauses, among other terms of the MCA agreements. So also, the professor is generalizing. There are a lot of different agreements out there, a lot of different agreements that differ from each other and that have different default clause acceleration provisions, as well as personal guarantees that are written differently, that are guaranteeing different things. So it's really hard to make a generalization about all MCAs. It doesn't work. It would be nice if you could, but you just can't. The following sections begin to explore this feature is a strong indication that recharacterization of MCA transactions as secured loans is appropriate. Well, Professor Schwartz would disagree. We went into that extensively. In fact, that's probably the main focus of his law review article, is no, that those are warranties. Those are quality warranties or performance guarantees. And so it's not appropriate based on recourse that these MCAs are just solely based on recourse. So it's a general statement that I think would be disputed by the Duke University Law School professor. Professor starts to talk about getting into the weeds a little bit and quotes from a case that the case law is remarkable for its incoherence, which I agree with. So the professor says this: when weighing whether a transaction style as a sale is a true sale, the core of the inquiry is to assess which party, buyer or seller, holds the risk, benefits, obligation, and other attributes typically associated with ownership. When an item of property is sold, the buyer takes on the upside and downside risk of that item's future performance. Not really. When you buy a car, you get warranties, you get guarantees of all kinds. There's a lot of protection. When a property is sold, it's not the end of the story. Usually, I guess it can be, but often it's not. A lot of purchases come with a lot of warranty. With a secured loan, in contrast, lender's entitlement to payment is not dependent on the performance or value of the underlying collateral. Like I just said, I don't think that's really the case. Obviously, I know what distinction she's trying to make, and the professor is correct in saying when you make a secured loan, the deal is you're going to get paid the value of the secured loan, no matter what, unless there's default. And when you're buying receivables, there may be a risk that the receivables will not be paid. So I understand what the professor is saying. I'm just disagreeing with the wording because I think it's I want to say misleading, but I think it's incorrect. Well, the professor says, like Professor Schwartz, professor is going to propose her own analytical framework to make this analysis easier, cut through all the chaos. And the first thing the professor said is that courts are letting these guys off too easy. They're not looking closely enough. The last 10 cases I read would tend to be evidence against that. But anyway, the professor's saying, look, if you're just going to look at the three elements, which is what the courts do now, and you don't look closely, these guys are sneaky. They're gonna draft agreements with those elements in mind, and you got to watch these guys. That's basically the tenor, I think, of this these statements. So here the professor goes through the standard list of factors, so-called factors, I guess, pieces of evidence that will indicate a sale or a purchase versus a loan. Number one, the seller's right to access collections or repurchase agreement. I've actually never seen that in my practice or even in a case. So I'm not sure why the professor is focused on that as number one. Number two, the buyer's risk of loss. Obviously, that goes to the risk guarantees. But you have to take a close look at that because if you're looking at a personal guarantee, what is the personal guarantee exactly? Is it a guarantee of payment? Or is it a guarantee that the merchant is going to follow the agreement? The extent of any pre-petition credit inquiries. Professor Schwartz would say that's irrelevant, but this professor considers that a factor. I disagree. The allocation of servicing obligations, again, this professor sees that as relevant. Professor Schwartz would agree with me and say it's not a factor. The language of the agreement, that's number five. Factor with some skepticism. Doesn't sound like that's going to be really taken that seriously here. The scope of the security and miscellaneous things. The scope of the security interest may be probative of the ultimate risk. And Professor cites Shoot the Moon, a case that was severely criticized by Professor Schwartz, I think was decided erroneously. In the case of MCAs, one additional point bears mentioning. A transaction that transfer percentage of identified receivables presents fundamentally low risk to the buyer. The sale of independent receivables would provide. Okay, so what? Does that mean it's not a sale? In a typical true sale of receivables, the buyer acquires no, not really. I mean, in a different kind of transaction, a buyer can buy separate receivables. Not clear what that argument is. Okay, so in this paragraph, Professor goes on for quite a bit on why that's less risky. Okay. So what? There's still risk. Even that risk is mitigated by the extensive collateral packages, personal guarantees. Yes, the risk is mitigated. So what? What's the point? So there's still risk. I agree. If there's no risk whatsoever, and the buyer of the receivables is absolutely guaranteed payment, then that's definitely more like a loan. But it's rarely like that. I mean, sometimes it's like that. I mean, there are situations also where funders are breaching the contract and not following either the spirit of the contract and lowering the daily payment amount because there are fewer receivables, there's less cash flow, or just ignoring provisions in the contract. There is an egregious case like that. However, that's breach of contract. Doesn't convert the contract into something else, which is, I think, a common mistake. All right. So here the professor cites cases where judges either found abuse or just found that the agreement was not a purchase and that it was a loan. So what? There are also cases that the professor is not mentioning where the opposite was true, where there was attempted abuse by the merchant who wanted to keep the money and then claim it's usury. So that happens as well. Those cases are not mentioned here. So the tenor here is that the good guys are winning, and not necessarily the case. There are a significant number of cases. First of all, I don't think it's good guy. I don't think it's us against the MCA funders. I think there are some MCA funders that may be bad apples, and there are a lot of MCA funders that are doing the right thing and providing emergency cash to struggling companies, which actually keeps companies out of bankruptcy and helps trade creditors. So it's the opposite of what I think it's the. I would take the stance the opposite of what this professor is implying by inflammatory language and innuendo. A sea change is beginning to emerge. First, merchant cash advance. The term is disappearing. I think these funders are going to disappear, and these struggling companies. What are they going to do? These are the financing sources of last resort. It's probably going to be more bankruptcies, especially if there's a recession. And then there's a comment about forum shopping, which is. I think that's the impact when there's an atmosphere of a witch hunt and all merchant cash funders are painted with the same brush. So they're going to go to friendlier. They're going to incorporate in friendlier states. I actually think this is a version of judicial interference with the legislative process. If Congress wanted to make a law, or even if states wanted to make a law outlawing merchant cash funders, then they would do that. Or they would clarify that there can't be a purchase of sale with certain factors. But they didn't do that. So I wonder whether there's even jurisdiction to do this recharacterization. So again, tenor is you got to watch these guys. These reconciliation provisions, they may be BS. They're not real, illusory. Maybe sometimes they are, or maybe they're not. I mean, if there's an agreement there, was there a dispute? As far I think there has to be testimony. There has to be evidence of whether there was an attempt to reconcile. And Shoot the Moon, I don't think there was an attempt to reconcile. We're just looking at the provision itself. I think courts have to dive deeper, but in a different way than what this professor is suggesting. I think they have to dive deeper into whether there actually was a bad faith abuse of a contract. The other thing is the professor often cites Fleetwood as an example of a court that's doing the right thing. Fleetwood is terrible precedent if you read that case because there are allegations, there are affidavits submitted that those funders were threatening to beat people up. Those funders were threatening. I'm not saying this is true. I'm saying there were allegations, there are affidavits submitted, may or may not be true, but there are serious allegations and a number of serious allegations that that particular funder was threatening to attack people physically and threatened to beat up a rabbi. So that's not any case where there's a funder who's allegedly threatening to beat up a rabbi is not your typical case. It's bad precedent. We're going to talk about the Mazzoni case. So this is a recent case, a district court case, not a bankruptcy case. And this is a perfect foil to Professor Bruce's article. So in this case, there's some bullet points. I'm going to go into the facts and you'll explain. And so this was a wellness center that was in trouble. Wasn't able to pay payroll apparently, went to these funders, cash advance funders, entered into the typical merchant cash agreements and sold the receivables and got financing. And when it came time to transferring the receivables, transferring the money from the receivables, instead of doing that, they sued the funders under RICO, tried to get a temporary restraining order, and did whatever they could to not pay and throw the book at their funders who helped them out. By the way, the Wellness Center also wanted to keep the money, of course. So, I mean, I just see this as abuse of funders because funders are extending, in this case, this is a significant amount of money, hundreds of thousands of dollars. And instead of complying with the contract, brings a RICO action. And all of a sudden, it's usury. All of a sudden, it's a loan. The contract that I read and signed, oh, that was nothing. The language is nothing. This needs to be recharacterized so it's declared a usurious loan. But thanks for the help. Thanks for helping us pay our payroll. There's a backstory. It's not really relevant. The Wellness Center was run by an officer, chief financial officer, did not inform, for some reason, not inform board of directors or the management that there were financial problems, went out and entered into this agreement, and then the management tried to get out of it and brought this RICO action. So the funders sued for breach of contract. Then the Wellness Center brought this action, and the district court notes that both violations, the RICO violations, usury violations, are premised on plaintiff's assertion that the LCF agreement and fund kind agreement are usurious loans under New York law. That's always the first issue. Are they loans? Are they purchases? What are they? So the judge applies the three elements, three factors, pieces of evidence, whatever you want to call them. Number one, whether there's a reconciliation provision in the agreement. Number two, whether the agreement has a finite term. Number three, whether there's any recourse should the merchant declare bankruptcy. And the judge looked at there was a reconciliation provision. So there is a reconciliation provision, and it's mandatory. Distinguishing those situations where it's not mandatory, I would say that even in those situations, unless there's evidence that reconciliation was refused, the courts should see those as purchases and not loans because of the existence, the possibility of reconciliation. But anyway, here it's mandatory. There's no argument. And of course, the Wellness Center, the lawyers have read all the case law. It's illusory. It's illusory. We read that in a case. So that's not what we're going to argue. The court said, well, no, it's not illusory. So they argue because you have to ask for it doesn't mean anything. It's BS. No, court, that's not correct. It's not BS. And there is a reconciliation agreement, which means it's more purchase-like because if the receivables go down, then the funder essentially gets less money. And the daily payment or whatever cycle that's on, that payment goes down. And so it's not a finite term by definition. I'm jumping on myself. And there's no finite term because there's a reconciliation provision. So if there are fewer receivables, the entire amount that's purchased of the receivables are not going to be handed over or transferred within a finite time. The length of time will be extended or could be extended. So it's not a finite term. Lastly, the agreement says, repeatedly states that a bankruptcy or insolvency filed by a shall not in and of itself constitute a default. So there you go. And the court is paying attention to the language and not assuming it's BS. Then the wellness argument makes this what's by now a standard argument that that there are guarantees, there are personal guarantees, so that the lack of a bankruptcy default provision is fully illusory. And the court says no, that's not the case because the court actually read the personal guarantee. But the guarantee provisions confirm that an event of bankruptcy is not an event of default that can trigger recovery from either guarantor. So it's a guarantee of performance. It's a warranty. It's not a guarantee of payment. What's interesting here is that the court obviously didn't quote directly from the personal guarantee, but in other opinions, we don't get to see the personal guarantee or the specifics of the warranties. And here you do, because the ruling is in favor of the funders. I mean, you could, by reading the facts section, you can see that the ruling was going to be in favor of the funders because it's inequitable. It's inequitable to proceed with a RICO action against funders that bought receivables and had a reasonable contract, and it's inequitable to let people squirm out of those contracts and keep the money. And the fact that how was the money used? It was used to pay probably to pay vendors, to pay payroll. And the court looks at the fund kind agreement, basically makes a similar ruling. I wonder. So this is district court in Pennsylvania. It's not a bankruptcy situation, and I wonder if it were in bankruptcy court in New York, whether the ruling would be the same. I really wonder. I think the bankruptcy courts, the implication of a ruling from a bankruptcy judge, and the judge is fully aware of this, that the unsecured creditors are going to be giving up possible income from preferences and possibly substantial income. And if the payment to these funders were made within 90 days. I think the judge, I'm not going to say bankruptcy judges are biased, but they're aware of their implications of these decisions. And there are very practical implications, and you could argue it's going to hurt unsecured creditors. So I think there's possibly more pressure on bankruptcy courts, or possibly a lawsuit for a fraudulent conveyance could bring in money to the estate. So a bankruptcy judge wants to bring in money to the estate, wants to help unsecured creditors. I think that's generally the bias, and I think that's proper. I think the bankruptcy code is written that way. It wants to bring money in, otherwise there wouldn't be preference sections and fraudulent conveyance provisions. But I think it causes bias in this situation because it's probably not as good for creditors. But I think judges should take into consideration where the money went. And it goes to payroll, and it goes to probably unsecured creditors. So they're really not being hurt. So this is a recent case, Southern District, New York, 2022. So when you read this case, you understand Professor Bruce's article. The allegations are just horrendous. This is a small Texas business, a golf course construction company, ran into trouble, couldn't pay its bills, and someone reached out to this company. So in other words, this was a broker that reached out to Fleetwood, which I think is important. Because it shows that they were solicited, maybe different from other cases. The court points out that there are personal guarantees and liens on everything, basically a security interest in everything. I yell it out, personally guaranteed Fleetwood's good faith, truthfulness, and performance of all representations, warranties, and covenants. So it's a performance guarantee, but that's going to be not really relevant anyway. So this was a nightmare for this golf construction company from the very beginning. It's in trouble to start with, and then They enter into an agreement. Funding company is supposed to buy 100K in receivables, and instead of getting a wire for 100K, they get a wire of 50K. So it's, to me, apparently it's breach of contract immediately by the funding company. But the funding company is still taking out a percentage, the same percentage of receivables as if they had funded the full 100K. And eventually, they debit over 100K, which not only doesn't make any sense, but anyway, and then with not only that, but the receivables slow down. There's a reconciliation provision, and apparently the merchant asked that the amount that's debited daily be less because there are fewer receivables, and the response is allegedly, unfortunately, we do not offer quote breaks. Doing that will put you in automatic default in all caps. So there's another breach, apparently, of the or allegedly of the merchant cash agreement. And then there are other facts that come out. The judge takes note that the New York Attorney General filed a petition against the funder, and there are other allegations. So there are allegations that the funder threatened people, that the funder threatened a rabbi in Brooklyn. Anyway, that's the allegation. Its harassment grew more intense with threats of a sexual and physical nature that the rabbi had to get an order of protection. So I don't think this is a. So these are the allegations. This is the background to the ruling. It's laughable. I mean, it's a nightmare. Well, I went back and looked at it again, and it says in connection with Fleetwood Agreement, Fleetwood granted Richmond a security interest in everything to further secure Fleetwood's performance under the Fleetwood agreements. Pamela and Robert. So these are securities. The court is saying these are securities for performance and representations and warranties. So both the personal guarantee and the security interest on other property besides the future account receivables was meant to secure performance and warranties. Yeah, I went back and looked at this, and notwithstanding the provision regarding reconciliations in the Fleetwood agreement, Richmond never performed a reconciliation. I think it's important to distinguish breach of contract from an agreement that has a reconciliation provision in it. That's one of the three elements. That's number one and number two, because if it has a reconciliation agreement, even though the contract was breached by the funder allegedly, if it had a reconciliation agreement, then it also had it did not have a finite term. Well, here it is. I found it. It's not easy to find. RCF will debit the specific daily amount of each business day, and upon receipt of the merchant's monthly bank statements on or about the 18th day of each month, it's mandatory, will reconcile the merchant's account by either crediting or debiting the difference from or back to the merchant's account so that the amount debited each month equals the specified percentage. So I read that as mandatory. But then it says RCF may, which is optional, may, upon merchant's request, adjust the amount of any payment due under this agreement at RCF's sole discretion and as it deems appropriate, notwithstanding anything to the contrary in this agreement or in any other agreement between the. Yeah, so I don't know. Is this mandatory? Is it non-mandatory? I think it's arguably mandatory. It's certainly the spirit of the agreement, and I'm sure that's indisputable that if there are fewer receivables, that the merchant will pay less or should pay less. That didn't happen here. So I see this more as a breach of this agreement, then as evidence, a finite term or evidence that this is a loan, not a purchase, because there is a reconciliation agreement. It seems to be mandatory. So if anybody was willing to bet that the judge was going to find that this was a purchase, I'd like to invite that person to play poker with me. Anyway, the judge goes into analysis anyway, and goes into the three factors, whatever you want to call them, three pieces of evidence, and goes into the reconciliation provision, explains why that's important. We've already done that ad nauseum. And here there's just basically a refusal to either, I guess comply with the reconciliation provision, since there's one there. Facts are terrible, but I think the court is wrong. The court seems to be saying that a funder cannot buy an income stream, has to buy specific receivables. If it doesn't buy specific receivables, then it's not incurring the risk of non-payment, which is not true, because a funder can buy an income stream and still incur risk, and that's been adjudicated in other bankruptcy cases. So this is a stark contrast to the Mazzoni case, and I think it's incorrect. And if Congress or state legislatures wanted to outlaw the purchase of income streams as opposed to the purchase of receivables, they would have done that. So this is court-made law, and I don't think the court has the jurisdiction to create new law. This conclusion or passage is confusing. On the most elementary level, the agreement places the obligation on Fleetwood and not on any account debtor to repay Richmond. There's nothing wrong with that. It's purchase of an income stream, and sets that sum not as a percentage of the receipts from account debtors, but as an absolute figure of the specific daily amount of $1,399 each business day. The court said earlier in the opinion that there was a reconciliation provision. It was breached, but there was one. So I'm not sure this is correct, because this amount should have been changeable if there was a reconciliation provision, regardless of whether any account receivables are collected. So either the agreement did have a reconciliation provision or it did not. And I'm not clear if it did or it didn't. It looks like it did have one and it was breached. Then it's breached of contract. That's different from saying it's a loan as opposed to a purchase. I think the judge is confusing guarantees of performance and warranties with guarantees of absolute payment. Of course, the facts are terrible, and the funder acted or allegedly acted as if there were no reconciliation agreement. But what exactly did the personal guarantee say? We don't have that in front of us. Was it performance? I think it was performance, because the judge quoted from it earlier. So the court goes on. Furthermore, the rights and risks that Richmond obtains do not bear any resemblance to the purchase of assets. Why is that? Richmond itself has no obligation or ordinarily no right to collect on the receivables. So what? It may still have risk. Because it breached the contract doesn't mean the contract's not a purchase. It has a reconciliation agreement, arguably. There's risk. And the personal guarantee is for performance. That was stated in the opinion. So just because it's a purchase of an income stream and not a purchase of receivables does not mean it does not bear any resemblance to the purchase of assets. So disagree with that. Richmond has no responsibility to contact Fleetwood customers. Indeed, it is given the right to collect directly from them only in the event of default. So what? The so what here is the conclusion that the risk of non-payment thus falls entirely on Fleetwood. It's not true, because of no receivables, and Fleetwood is not going to be able to transfer the receivables if there are no receivables. So there's a risk to the funder under this agreement. Seems to be. The failure of an account debtor has no consequence on the amount due. Not true. If there's a reconciliation provision, that simply is not true. If a Fleetwood account debtor failed to pay its debt or becomes insolvent, there would be no reduction in the purchase amount. Or on Fleetwood, the purchase amount would stay the same, or on Fleetwood's obligation to pay the daily amount. No, that would change pursuant to a reconciliation agreement. And in this situation, one might ask, well, if there had been a reconciliation agreement, did the merchant try to reconcile or ask for lower payments? And they did here. So it wasn't that the agreement, that the provision was illusory. It was that the funder breached the agreement. That's another way of looking at it. I mean, it's possible. I mean, the language is unclear, but you could certainly make the argument that there was a mandatory reconciliation agreement, or at the very least, the meeting of the minds in this merchant cash agreement was that the payments would be lowered, and they weren't, and there was just a blank refusal. That's a breach, not necessarily. It doesn't convert the agreement into something that it wasn't. So the merchant didn't have to keep the receivables in escrow, didn't have to separate them, could use them, just had to pay the daily percentage. And so the court concludes, well, Fleetwood didn't buy anything. This doesn't look like a purchase. And I disagree with the court's analysis here. It's the purchase of an intangible. And I think that the more logical approach would be to recharacterize this agreement as a purchase of an income stream, which is what it obviously was. It was not a purchase of individual receivables. I think it would be more accurate to do that than to recharacterize it as a loan based on the agreement itself, not how the funder operated, which is separate, which is breach of contract. The court goes on. Under the agreement, Fleetwood and Pamela and Robert Fleetwood as guarantors have the obligation to conduct due diligence and credit checks. So what? It's, it's, it's not evidence that it's a purchase. It's evidence that there are warranties, that the income stream uh, is being sold with a warranty. There are warranties and representations. There's a representation which is a warranty, that Fleetwood is obligated to expend its best efforts to maintain and grow its business. That's a warranty. So there'll be receivables. So this is another MCA case. I wanted to talk about this case because it has a confession of judgment, and yet the court found, this is a state court, not a bankruptcy court, found that this was a purchase of receivables, and not a loan. I love these cases. So these guys obtained financing, sold their receivables, and then when it's time to hand over the receivables, they breach and they sue the funder for usury and under RICO and try to keep the money. So this is a tale of two funders here, and the lesson I draw from this is a funder better use the right form, better use the right boilerplate, or the funder is going to get into trouble. In this case, there were two funders, Arch Capital Funding and Capcall LLC, and the judge found that one of the funders had a mandatory reconciliation provision, and the other funder, Capcall, did not. The other funder had a provision that said that Capcall, the other funder's name was Capcall. Capcall could view the seller's bank account in order to calculate the amount of the seller's daily payment, but there was no specific provision requiring that the amount be changed. Again, I see this as not strong evidence that there was an intention not to reconcile, and the judge is going to address this later. But I think there has to be evidence that there was a request to reconcile that was denied for the court to conclude that there was no reconciliation. I think reconciliation is part and parcel of these agreements. That's the understanding of the parties. It's the reasonable interpretation of these contracts, every one of them. That's why merchants enter into them, because they're told that the amount of the payment is going to be based on the receivables. It's not a loan. It's not a set payment. That's their understanding in every case. That's my impression. That's their understanding of the agreement, and I think that's probably the representation of the funder in every situation. So the plaintiffs are arguing that they didn't know this was a purchase and sale of receivables, had no idea what was going on. They thought they were loans, but they didn't realize that they were usurious loans. And then later found out, not in the agreement, that they were usurious loans, and they didn't want to pay them back because of that. Kind of a wacky argument, in my opinion. For plaintiffs to say, and the court gives a lot of credence to the actual writing in the agreement. You'll notice where in cases that the court eventually finds and rules that the contract was a purchase and not a loan, the court respects the agreement, the writing in the agreement between the parties that both parties have supposedly agreed to and read. For plaintiffs to state that they would not have entered into a purchase or sale if they had known that is what they were doing is utterly undermined by the documents themselves. It says they say all over the place, this is a purchase and sale of receivables. So these funders buy receivables in good faith. The contract is clear what they're doing, and they end up getting sued for RICO, getting threatened maybe with a jail term for criminal usury for their efforts, and not getting paid back their money, not getting paid back with their receivables. Yeah, the court goes into the importance of a reconciliation agreement, which I think is central to these agreements. That's what people are agreeing to, and that it's not a finite term. If it has a reconciliation agreement, it cannot have a finite term. It's impossible because there could be more or less receivables that the merchant is collecting, and therefore a longer or shorter, or well, it's not going to be shorter, but a longer or longer payment term. As far as recourse, the court says in the Capcol agreement, the bankruptcy is a basis for declaring a default, and in the Arch agreement, there's a confession of judgment should the merchant file for bankruptcy, and a personal guarantee might be or will be enforced. Doesn't really go into what the personal guarantee is. Just says, well, we're gonna weigh that against this being a purchase in favor of being a loan, but everything combined, especially the reconciliation agreement, we're going to find that the Arch agreements are in fact purchases. There's enough riskiness to it. So again, Arch case gets dismissed. Again, they're suing. The merchant is suing under RICO and to declare a usurious loan, and the case against Arch is dismissed. But it's not dismissed against Capcol. But there's no resolution of the Capcol yet. And the whole issue is it doesn't have a reconcile. It doesn't have a specific provision requiring mandatory reconciliation. The form is no good. The boilerplate in the contract is no good, and that's what's causing the trouble. And the court may decide to take evidence on whether there was a request for reconciliation or not. I don't know. Hasn't been, that issue has not been resolved as of this in this opinion. It may be resolved by now. I don't know. Situation where a small company is rescued by a merchant cash funder and financed to the tune of over $300K. And when it comes time to pay back, the company decides, oh, you know what? This was a user's loan. I'm not paying anything back. And maybe try to put you in jail. I guess these small companies, their lawyers read the case law. Let's give it a shot. Why should we have to pay back $300K or whatever is now owed? I think here it was like 150 in receivables, something like that. Why should we pay that back? Let's see if we can skate by making some clever arguments based on case law. So anyway, didn't work here. The judge refused to buy those arguments or dismiss. In this situation, it's a state court claim, New York State Court, by the funders for breach of contract, trying to get the receivables that they paid for. And the judge was not buying the defendant's arguments. So they got the purchase. The purchase was for. First question is there a reconciliation provision in here? And there is. In the case of this agreement, as amended, it contains a reconciliation provision. Section D of the amendment provides that no less than every 2 weeks after the funding of the purchase price to merchant, either purchaser or merchant may give written notice to the other party, providing for an adjustment in the specified daily amount based upon the daily average receivables during the preceding calculation period. So the defendant argued, it's illusory. I love that. I think illusory has become like the word to describe reconciliation agreements or provisions that merchants don't like anymore. Anyway, the court found no, that's not true, and it was just basically here the defendant was saying, well, it never happened, and therefore it's a sham, it's illusory, and it's a usurious loan. Put him in jail. But their only support for this assertion on this motion is an affirmation of counsel, and even that affirmation does not state whether, for example, this was ever asked for. And that's exactly the question to ask. Did the merchant ever ask for a reconciliation? I think no matter what the provision says, whether it's mandatory, whether it's discretionary, whatever it is, even if it's not there, I think the question is, did the merchant ever go to the funder and say, look, we don't have the receivables that we thought we were going to have, that we represented to have or would have. Cannot pay this nut anymore. The percentage, the amount that's stated in the agreement is no longer accurate. It's not the right percentage of our receivables that we're actually getting. So let's lower the amount. Let's lower the daily sweep amount. And that's a reasonable thing to ask in these agreements. And if the funder refuses, then I think it should be declared. Then the agreement later, in whatever context litigation comes up, should be declared to be a loan. And I think that's the major question, though. Not just the provision, but whether it was ever requested. Not just the boilerplate, but what actually happened. I think that's important. That's what this judge does. This is what happened. Did they ask? No, they never asked. I love this judge. Unfortunately, he's not a bankruptcy judge, so I'll never be in front of this judge. The thing this judge does that I think is correct is that it looks at the language of the agreement. I'm going to skip to this part to the basically the fourth or fifth paragraph. Similarly, the amendment provides for the collection, when he's talking about whether it's finite or not, the second element, the amendment provides for the collection of a specified amount, subject to periodic adjustment until the purchaser receives full purchase amount. It's respecting the language, which I think should be respected, unless there's a reason not to. And Professor Schwartz agrees with me. The language is important. Respect the deal that these people made. Then the court looks at the recourse issue, and there's a personal guarantee, and the personal guarantee provides, and this is the last paragraph, that in the event of the merchant's bankruptcy, he is required to perform the merchant's obligations under the agreement. This recourse provision weighs to some extent in favor of treating the transaction here as a loan because there's a bankruptcy default provision. At the same time, though, the scope of O'Neill's obligations under the recourse provision of the guarantee is itself limited by the contingent nature of the merchant's obligation under the agreement in light of the reconciliation provision. This analysis is what's not done by other courts. So it's limited and it should be weighed less as far as the purchase sale analysis goes. Ultimately, it's a balancing test. The judge finds in favor of the merchant. This is an excellent opinion. This is how, but would another court rule this way? I don't think so. I think the bankruptcy court, we've seen bankruptcy courts issue rulings that I don't think they would agree with this ruling. They'd find a lot, they wouldn't agree with this rule. They would issue a different ruling based on the exact same facts. And that's the problem. That's exactly the problem. No one knows what a court's going to do. There's too much. There really should be Congress or state legislators should step in and clarify the purchase of income streams and what's a purchase and what's not a purchase, because the courts really don't know what to do. This is the last case I'm going to talk about. So this is the first case that Professor Schwartz criticized. We'll go into that. It's also the case that's cited by Professor Bruce in a good way. And it's also been cited by a number of other recent cases. I think it's a very erroneous decision, and I'll go into why my opinion is. And I'm basically agreeing with Professor Schwartz on this. So this is a 2021 case, bankruptcy court level. in Montana Bankruptcy Court. Basically, Shoot the Moon was an LLC that eventually owned a number of other LLCs. There were basically restaurants in Montana and other states. They ran into trouble in the 2008 recession, apparently didn't have enough cash to finance their operations, and used cap call as well as other MCA, merchant cash advance entities to finance their operations and enter into a contract with the cap call. So the judge describes the basic transaction, which looks like a typical MCA transaction. There's a specified daily amount. There's a purchase. The contract is a purchase of future receivables, income stream, not specific receivables. And the court notes at the very beginning of the opinion that there are emails between a Mr. Leak, who was apparently a representative of Capcall, referring to these transactions as loans. So procedurally, this is a little bit unusual. Capcall sued for turnover of its property of receivables that it purchased that were being held by a third party, and the bankruptcy trustee counterclaimed for an avoidance action under the preference laws. So the big question, as it always is with these MCA cases, is was this a purchase of receivables, income stream, or was this a loan? If it was a loan, the trustee is alleging it was a usurious loan and a preference. So the first thing the court does is quote heavily from a law review article that Professor Schwartz says got this whole thing completely wrong and is citing variables that are either overweighted or irrelevant. Second thing the judge does is recite it's a multi-factor test. No individual factor, a combination thereof is determinative. The inquiry is not quantitative exercise susceptible to replication by a computer program, but a comprehensive and heavily contextual endeavor. That said, a consideration that overlays and unites the factors is how the parties allocate risk. Okay, no one's disagreeing with that. If there's no risk, it's a loan. And the question is there risk? Well, what factors are you going to look at and what factors are you going to weigh to determine if the purchaser is accepting a risk here? And that's where I disagree with this judge's opinion. And that's where I think Professor Schwartz disagrees. And I think other judges would disagree on the facts of this case. Well, the judge concludes in the previous page that these are loans, not purchases. So why is that? So first, the security interests reflected in the transaction documents are significantly broader than those associated with a sale and much more akin to those associated with a loan. Well, Professor Schwartz said that's not relevant, that these are securities of performance, securities of qualities. And that's why the professor identified this case as the first case that he's criticizing, because this court is not distinguishing the reason for these to secure performance and to guarantee the quality of their receivables. So that's the first thing. The other problem right away is that the judge says, well, these look like loans, and of course they look like loans. And as Professor Schwartz pointed out, you can't distinguish loans from purchases that way because they look exactly the same. It's a purchase of a receivable, of an intangible, and it's going to look exactly like a loan. So it's a faulty analysis. Yes, of course they look like loans. There's a security interest. Money is flowing back and forth, and it doesn't mean it's not evidence. It's irrelevant. It's not evidence that it is a loan. So the judge says there's no reason why Capcall should receive and perfect security interests in assorted assets other than the purchase. I respectfully submit that this is wrong. And I think Professor Schwartz would agree with me. There is a reason. There's a context here. This is like, after 2008, these restaurants are struggling and eventually filed bankruptcy despite getting financing. And this is a very risky transaction for a funder. Yes, they're going to want to get a security interest in everything to secure performance, to secure compliance with the contract, so that the entity the entity that they're funding, which is in desperate shape, make sure that these receivables, the percentage of receivables that have been agreed to pay Capcol are in fact there to pay Capcol. Then the judge says Capcol's financing statements contain another revealing indicator that they relate to secured loans. They identify each applicable shoot the moon entity as a quote debtor. This is telling because Capcol could have easily referred to each as a seller or words of similar import. Well, respectfully, this is incorrect. And Professor Schwartz pointed this out, and even Professor Bruce agrees with this. It's a form. It's the same form. You have to use the same form. It's boilerplate. It's a boilerplate form. You can't cross things out. It's a UCC form, and it's not evidence of a secured loan. It's evidence. It's the same form that's required whether you're buying receivables or whether you're lending against receivables with the receivables as security. It's the same form, so there's no difference. Again, there's a confusion because this is a purchase of intangibles because it looks exactly like secured loan. It's very difficult to tell them apart, except for the language in the contract and other elements. The judge goes on and looks at other recourse types, personal guarantee and confession of judgment. So this is true probably in every MCA, and courts have found that despite these personal guarantees or confession of judgment, it can be the transaction can be characterized as a purchase and not a loan. And Professor Schwartz says this is a guarantee of performance. This is about the credit of the company, or more importantly, the owner of the company. These are typically small companies that the owner is going to comply with the contract. And again, this is a recession. This is a restaurant. This is a restaurant that's in deep trouble. This is a business that can't get financing anywhere else. This is by its nature a very risky funding situation. So of course you want to get guarantees. You want to hold their feet to the fire to make sure that there's compliance and that the money is going to be deposited in the account and not transferred elsewhere. This is a desperate situation. So of course funders are going to want these kind of guarantees, which is commercially reasonable. And Professor Schwartz agrees with me, points that out in detail. Well, the court says, although none of these features is dispositive alone, well, respectfully, I don't think they're dispositive at all. They're not really relevant. And I'm agreeing with Professor Schwartz here. They're just not evidence relevant to a determination whether these transactions or loans or purchase. Okay, then the court goes on to say that it's highly unusual. These rights, remedies, and potential control is highly unusual in the context of an asset sale. Respectfully, I disagree with that. Every asset sale typically comes with warranties and guarantees. Maybe not in the exact same format, but to give a simple example, again, when you buy a car, there are warranties, there are guarantees in the contract. It's typical. Because if you're going to buy in any asset sale, typically there are going to be warranties and guarantees of either performance or of quality or of both. So it's not unusual, respectfully. So then the judge says the business actors often discuss the transactions in vernacular reserved for debtor-creditor relationships. So what? It's not relevant to interpreting a contract that has specific language labeling this as a purchase of receivables. Why should that be considered as evidence? Professor Schwartz says it's not relevant. There's also the issue of commingling receivables in a bank account. How is that relevant? And Professor Schwartz says that shouldn't be considered either. It's not a relevant factor. The merchant can do whatever it wants with the receivables, and that's true in every single case, fact pattern where the purchase of an income stream is considered, whether it's a purchase or a sale. Each account receivable is not being funneled into a special segregated bank account. They're all being commingled. So this is not relevant either. So the court goes on to say that, yes, these were called purchases of receivables, shall not be construed as a loan, but the judge dismisses that out of hand. There's no weight whatsoever, self-serving, and we're going to ignore what was actually said in the contract between these parties. that voluntarily executed the contract, that entered into this contract. Not relevant what was actually signed by both parties. So here we go. In one sentence, at the very end of all this analysis, we have this. Here, at least some agreements include reconciliation provisions and none specify a fixed term. So these are the two most important factors. This is the first factor and the second factor considered by most courts. And it's relegated to the end here. It doesn't matter. It's overwhelmed by what I think to be is irrelevant factors. It should have been considered first. It's the most important thing. So about reconciliation, the finite and the non-finite nature of these transactions, there's nothing. There's no discussion. Was there reconciliation? Did the merchant seek to lower the payments at any time? No discussion of that whatsoever. No reference, no quotes from the contracts with respect to reconciliation. No discussion that these are not finite transactions. And the reason for that is that the court needs to take a holistic approach, which excludes, respectfully, all the relevant factors to determine whether this is a loan or a purchase. So the result was not pretty for Capcall. Capcall this was found to be obviously a loan. These transactions were loans, not purchases, according to the court. Capcall was found liable for a huge preference, which I'm not going to analyze, and also was found to have violated Montana usury laws. And the judge threw the book at Capcall to a huge extent. I think this entity, Capcall, is no longer in business. So here the court talks about the personal guarantee, and agreement also provides that in the event of the merchant files for bankruptcy, protection are placed under an involuntary filing. Protection 2 and 3 are immediately invoked. Protection 2 allows Richmond to enforce the provisions of the personal guarantee of performance against the guarantor. Well, I don't know what that means. They can enforce it, but what are they enforcing? We don't know. We don't know exactly what the personal guarantee is. They may not be in default. The personal guarantee, just because there's a bankruptcy, does not necessarily mean that any of the performance guarantees of performance or warranties as to quality of the receivables have not been met. We don't know unless we see that personal guarantee. So that's a question mark. So it's not automatic. It's not. The court doesn't say there's a personal guarantee to pay in full, to repay in full the purchase price, no matter what. I don't see that here. It says the funder has the right to enforce the provisions of the personal guarantee. I don't know what that means. Then there's a confession of judgment in favor of Richmond in the amount of the purchase amount stated. Well, what does the confession of judgment say exactly? And when is that triggered exactly? Fleetwood authorized Richmond to execute if there's a bankruptcy. But if there's a bankruptcy, any judgment is going to be stayed by the automatic stay. So how are they going to execute it? It's going to be stayed. So it's going to be what? Like an unsecured claim in the bankruptcy case? For what? It just seems like it's probably a meaningless provision. So I'm not sure how much weight I'd give to that in the context of deciding whether this is a purchase or a loan. It's meaningless. It would be a violation of the automatic stay. They can't execute anything. So I'm not sure what that means, if anything. And then it goes into the more in detail to the personal guarantee by the owners. Courts have observed that personal guarantees are considerations pointing toward treating the agreement being treated as a loan rather than a receivable purchase, but have also observed that personal guarantees that are limited by the contingent nature of the merchant's obligations under agreement may not render the agreement a loan. Here, the guarantee is tied to the merchant's obligations under the agreement. So, but these obligations are not contingent upon the receipt of future receivables. If Fleetwood declared bankruptcy, it would be subject to a confession of judgment. Well, I think that would be stayed. So I'm not sure Fleetwood would be subject to anything. And it's not clear to me exactly what would trigger the confession of judgment. I'm not seeing verbiage on that. It just doesn't seem to be cited here. They're not going to be paid back. I don't think the funder is going to be paid back. Even if they have a confession of judgment, it's going to be maybe an unsecured claim. It's certainly going to be stayed. If there's a bankruptcy, it's stayed immediately. So it's meaningless. So should that be weighted heavily in determining that this is a loan, not a purchase? has a meaningless agreement, meaningless provision in there. And then the court talks about the guarantee, which is limited by the contingent nature of the merchant's obligation under agreement. The court concludes, thus, under the agreement, there are virtually no circumstances where, if the accounts receivable would not be sufficient to pay the purchased amounts, Richard would not be absolutely entitled to repayment of that amount by Fleetwood. Well, I don't know. Then maybe they would be arguably entitled to payment. Well, I don't think the personal. It's certainly not demonstrated here that the personal guarantee would entitle them to repayment. The confession of judgment is more troubling, but it's a worthless confession of judgment because it's stayed. They're not going to execute anything. So, does the fundamental question that was asked at the beginning of this opinion is, does the funder take a risk? Absolutely, the funder takes a risk. At best, if there's a bankruptcy, they're going to get an unsecured claim, according to this agreement. What else are they going to get? So the judge finally takes a look in detail at the reconciliation provision. It seems to me that this is a matter for interpretation, but the judge interprets this as the funder has discretion over changing the daily amount, doesn't have discretion over reconciling, but then has discretion about changing the daily amount. To me, this is if there were a request, and there was allegedly in this situation, that there be a reconciliation, that the amount changed, I would think a state court would find this to be breach of contract and bad faith on the part of the funder. If there's an unreasonable refusal to change the daily payment amount, because that's the meeting of the minds. It's obviously what the parties intended. It's the basis. It's an essential part of the agreement. So I still would make the argument that this is more of a breach of contract, but this is an element that's going to be that certainly could be weighed in favor of finding this to be a loan, not a purchase. But I think there's a lot of ambiguity here, and it seems to me that this is more of a breach of contract, especially since there was a request. And if there was no request, I think it's an evidentiary question. I think there has to be testimony. You know, in a situation where there's a reconciliation agreement like this, let's say there was no request, or there was no need, and the receivables were steady, and the merchant decided reconciliation was not necessary. Would this kind of provision convert this contract into a loan? I don't think it should. I don't think it should be weighed that heavily, especially if there's no need for reconciliation. Here, I think it's a breach of contract and bad faith not to reconcile. Since obviously there's a provision for reconciliation, why have that if the daily amount's not going to change? I think I think a court would find against the funder in a breach of contract action, which means it's not an issue of recharacterization. It's an issue that this is a contract for a purchase that's been breached. That's different from recharacterizing it as a loan. So what's the takeaway from all this? It's a mess, and I think either Congress or state legislators should weigh in here and set some parameters, because people don't know what to do. Funders don't know if they're going to be liable for usury, and merchants are also taken advantage of in certain situations. So there needs to be clarity. So there are a lot of variables, and this isn't even all the variables. And each court has a different approach to weighing the variables, or even considering any of these variables. Some of the courts will not even consider as relevant, and there's a lot of disagreement. And the facts are different in a lot of these cases. So are we comparing apples and oranges? Or are we comparing the perspectives of different kinds of courts? State courts, district courts, bankruptcy courts? It's a chaotic situation. It's very hard to predict. And there's no guidance from the statute. There's certainly no guidance from the bankruptcy code. And I don't think there's any statute anywhere that's of any guidance. Judges have a very difficult job. And I clerked for a judge. I clerked for 2 judges. I know they have very difficult jobs. They work very hard and they're underpaid, especially in a situation like this. Who knows what to do? If you look at global, the victim is the funder, purchases receivables, purchases an income stream, provides emergency financing, and then the other party tries to renege on, not only renege on turning over the receivables, but accusing the funder of being involved in usury and filing a RICO action. On the other hand, you have the other situation where you have a funder apparently taking advantage, allegedly attacking a rabbi, and those are the two extremes. Are these guys engaged in criminal usury, or are they saving businesses and being the last resort for a lot of companies that otherwise would go out of business? Maybe they should go out of business. There are a lot of questions. There are a lot of questions here, and I think it depends. It does depend a lot on the facts, but it's not just the facts because judges are taking entirely different approaches to just the basic concept of buying an income stream. In the recent case in Southern District, New York, the judge is basically saying you can't do that. You can't buy an income stream and consider that a purchase. That's a loan. Whereas other courts are saying no, you can buy an income stream. So there's a lot of confusion. The lawmakers need to come in and make some law and clear this up. Thanks for watching. So I've been practicing bankruptcy law 20 years, specializing in preference defense, fraudulent conveyance defense, and I've never seen such confusion with respect to basic principles like can you buy an income stream or does that have to be a loan? The other thing that's really thorny here is that a lot of these agreements, merchant cash agreements, are different. And so the court has to look at each separate situation and apply variables, and no one knows what kind of variables to apply or how to weigh them. Courts do that differently. So anyway, thanks for watching.